On this episode of Law Weekly, we talk about the need for a brand new constitution for the country, the lessons from the End Bad Governance protest, the Supreme Court judgment on local government autonomy and its implementation, and much more. My guest is the distinguished Professor of Law, Professor Taiwo Shikpiton of the University of Lagos. Also on the program, the National Judicial Council (NJC) recommends Justice Kudirat Kekere-Ekun to President Bola Tinubu for appointment as Chief Justice of Nigeria, plus a recap of the top stories from the courtrooms. Hello and welcome to the program. I'm Shola Sheyeli. My guest, Professor Taiwo Shikpiton, is a distinguished professor of law and a senior advocate of Nigeria. He's a well-accomplished legal practitioner with a career that has spanned over 4 decades. His expertise spans across general commercial litigation, international arbitration, energy and construction law, insurance law, white-collar crime, election petitions, public law litigation, trial advocacy, and the law of evidence. I began our interview by asking his thoughts on the call made by the Patriots, a non-partisan group of eminent Nigerians led by former Commonwealth Secretary General Emeka Anyaoku, who last week urged President Bola Tinubu to convene a National Constituent Assembly to produce a People's Constitution for the country. What are the defects of the present constitution that warrants the call for a Constituent Assembly, a referendum, and a brand new constitution?
Let me start by saluting the high sense of patriotism of the group led by Emeka Anyaoku in terms of the search for People's Constitution. I want to say that the Constitution itself, which we operate, is not a perfect document because it was crafted by mortals like you and I. And only God can lay claim to perfection. It's not perfect. But I think an amendment of these defective areas will take us to where we are going, as opposed to asking for an entirely new constitution. Areas of concern include the area of devolution of power. That too many powers or too many functions are given to the federal government or to the central government, federal government, under the exclusive legislative list. There's a need to unbundle it in terms of quantity and quality. For example, you're talking about marriages. You're talking about some issues like police. You're talking about different minor issues which should be allowed to be at the state level. So I believe that is what is really causing the problem. The center is too attractive. So there's need to unbundle it. Of course, there are also concerns about revenue allocation in terms of physical federalism. And I believe that those issues can be solved by amending the Constitution, as opposed to
calling for a brand new constitution.
Brand new constitution is a very serious business, with profound respect to all concerned. You're talking about you wanting to have elected representative of the people of Nigeria. How do you get that? By voting. But in voting, you find out that people who can vote are people who are 18 years and above. Those below 18 years, are they not Nigerians? Are they not Nigerians?
So you create a whole set of problems.
It's also a theory. Again, what is the assurance that when you vote, you are going to bring out the true representative of Nigerians in an area, in a country where people have perfected rigging of election? So I would caution that it is not possible, legally speaking and factually speaking, for all Nigerians to be represented or to have a say in the Constitution. So let us stop all these quest for new Constitution. We have a document that is working, and I've always said clearly that our problem is not the Constitution. It is about leadership and followership. A good Constitution in the hands of bad operators will not lead us anywhere. And a bad constitution in the hand of good operators will lead us to the promised land. So we need to go back to the drawing board and have and cultivate a sense of patriotism. Nigeria today, as a nation, remains an orphan because most people, most Nigerians, will think of themselves first and their immediate family. Nigeria comes last. Let us imbibe a sense of patriotism, and you'll see how well the Constitution, as amended, will take us there. I like the President's response, that he is more concerned with the welfare of the people, how to grow the economy. When you finish with that one, then you can come back to the Constitution. If you have good leadership and good followership, yours truly will all be happy in this country.
Prof, I noted what you said about leadership and followership. The Patriots had also said that the challenges of national unity, insecurity, poverty, and hunger, some of which form the basis for the End Bad Governance protest, are symptoms of the inappropriateness of the Constitution that we presently have. But what, for you, are the lessons from that protest, and how can we proceed as a nation going forward?
I think that looking at the protest, you discover that it was something that in Lagos, except for Jota area, I didn't see much of activities because the Lagosians have learned their lesson in terms of the NSAS protests. So those who did it in the north, I hope they have also learned their lessons. But the bottom line is that majority of the youth in some places are not educated, and they are also not gainfully employed. That has nothing to do with the Constitution. It is about governance. How are the governors governing the states is what we should be asking. You have instances of money paid for work not done. You have roads being rehabilitated twice or thrice on paper, but in reality, nothing is done. Tell me something, is that about the Constitution? It's about those people who operate the Constitution, and also some civil servants who teach politicians how to siphon money. So as we beam our searchlight on Mr. President, we should also beam our searchlight on our state governors and also on our local government chairmen, and hold them to be more responsible and more accountable, because they are nearer the masses. And whatever is happening at the state level, any aggression at the state level being transferred to the federal is uncalled for.
Since you talked about government that's closer to the people, I want us to go back to that Supreme Court judgment on local government autonomy. There's a relief there that says that monies due to the local government should be paid directly to the local government. And some lawyers have argued that this is at variance with Section 162 of the Constitution. Do you think that the Supreme Court made the right call there, or shouldn't that section of the Constitution have been amended first?
That decision attracted a majority decision and also a dissenting opinion of Abiru JSC. Well, if I have to analyze the provision, then we'll have to call in aid the rules of interpretation of statutes and the Constitution. So bearing in mind that the Constitution is a living document, an enduring document designed to achieve the happiness of the greatest number of Nigerians, if not all Nigerians. There are two rules of interpretation. If you go strictly by Section 162, that money should be given to the state that will now pay it into the joint local government account.
Which some of them have not been doing.
That is a literal interpretation. But then, if you interpret a law in a way, ordinarily that calls for an amendment to achieve the objective. But lawyers and judges are what we call social engineers, in the sense that they use law to solve problems of the society. Supreme Court saw that the federal government, the federal government were in trouble with some governors. So what do you do? If you apply the literal rule, status quo will remain. So you have the golden rule of interpretation and you have the mischief rule. What was the mischief sought to be achieved by allocating or suppressed by allocating funds to local government? The answer is to ensure that monies are made available to them to develop. And if the money is not made available to them, what then do you do? The mischief rule instructs you to say, well, how do I suppress the mischief of starving them of funds? Give it to them directly. It may not be the best approach, but it's designed to solve a problem that we all see. If you go by the literal rule, that means that those local government will be starved of funds, and you will have defeated the objective of the Constitution. So if I may summarize, it's a case of literal rule of interpretation versus mischief rule of interpretation.
With that judgment, does that mean that there's no need to amend the Constitution anymore?
Well, that judgment forms part of the sources of our law. But sometimes the judgment of the court may be a pointer to the fact that there is need for legislative response. I will say that for the avoidance of doubt, the Constitution should be amended along that line to reflect the judgment of the Supreme Court.
Let's talk about the judiciary under the outgoing Chief Justice of Nigeria, Justice Olukayode Orunbola. How well would you say that he has fared? And particularly, let's focus on what more can be done to improve the justice system, in terms of an agenda setting for the incoming CJN.
Looking at Justice Ariwola's scorecard, for the time he has spent there, I would say that he has tried. Yes, mistakes might have been made along the line, but because he is a mortal like you and I, he's not above mistake. But one thing I'd like to give to him is the fact that he's able to hold the court together, and that for the very first time, you have full complement of the Supreme Court. Since 1999, it did not happen. It happened through him, under his regime. That's not a mean feat. It's something that is commendable. And the effect of it is that we are beginning to see that cases are moving faster. They have 2, sometimes 3 panels sitting at the same time, clearing as much backlog as you have to be, that can be cleared. So in terms of speedy disposal of cases in the Supreme Court, I think that's something commendable on his own part. But again, in terms of the agenda for the for the incoming CJN, yours truly, there will be need to amend the Constitution to ensure that you reduce the number of cases coming to the Supreme Court. This may call for you having state Court of Appeal and state Supreme Courts to take care of those cases that are not going to go to Supreme Court. But there's need for us to look at it very well and ensure that we get it right. Again, I love to see an agenda whereby for the first time in so many years, my colleagues in the academic and some brilliant and forthright senior advocates going straight to the Supreme Court. I can tell you that they will make a difference in terms of enriching the jurisprudence of the cases coming from Supreme Court. Those cases that I read are not too challenging, maybe because of the workload. But I like to plead that give the academics and also the inner bar a chance. One slot. Abiru that is there today, that through that is sending judgments, and you expect more from him, has a background in the academics. I want to make a promise on behalf of those 2 constituencies that our jurisprudence will be richer if you can just make sure you get them appointed. Again, that also calls for the manner of selection. I will have to plead with this new incoming CJ that as much as possible, we need to resist incursion to the judiciary by the politicians. What I see here now is that you find a lot of politicians, legislators, and also governors trying to push their own people, either to the High Court, Court of Appeal, and Supreme Court. People who have no passion for the job, people who don't even have the intellect for the job, are getting there. And when they get there, their decisions are questionable, conflicting, and sometimes not possible to rationalize. So we need to tighten the belt in terms of the appointment of people and the quality of people appointed. Those are the few agenda I'd like to set for Honorable Justice Kekere as she comes in.
Welcome back. The National Judicial Council (NJC) at its 106th meeting, presided over by the Chief Justice of Nigeria, Justice Olukayode Ariwoola, has recommended Honorable Justice Kudirat Kekere to President Bola Tinubu for appointment as the Chief Justice of Nigeria. Now, this is imperative as Justice Ariwoola will formally bow out of office as the Honorable Chief Justice of Nigeria on Thursday, August 22nd, 2024. Justice Ariwoola, who assumed office on June 27, 2022, will formally retire from the bench upon attaining the mandatory retirement age of 70. Given her status as the next most senior justice of the Apex Court, Justice Kekere had been widely tipped to take over from Justice Ariwoola in line with tradition. When she assumes office, Justice Kekere will become the second female justice in Nigeria to hold the topmost position in the third arm of government after retired Justice Mariam Aloma Mukhtar, who was CJN between July 2012 and November 2014. Born on May 7, 1958, the incoming CJN, Justice Kekere, is 66 years old and may serve for up to 4 years compared to the average 2-year tenure of her predecessors. She obtained her LLB in 1980 from the University of Lagos and was called to the Nigerian bar in July 1981. In November 1983, she obtained her LLM from the London School of Economics and Political Science. From 1985 to 1989, she was in private practice and was later appointed a Senior Magistrate Grade 2 of the Lagos State Judiciary in December 1989. She was appointed a judge of the High Court of Lagos State on July 19, 1996. She would later become chairman of the Robbery and Firearms Tribunal of Lagos from November 1996 to May 1999. In September 2004, Justice Kekere was elevated to the Court of Appeal, and she served in various divisions, becoming the presiding justice of 2 divisions of the Appellate Court, Makurdi and Akure, in 2011 and 2012, respectively. She was elevated to the Supreme Court of Nigeria as the 5th female justice of the Apex Court and sworn in on Monday, July 8, 2013. After spending 11 years at the Apex Court, Justice Kekere will not only become the next CJN, but will also head the National Judicial Council (NJC), which oversees the appointment, promotion, and discipline of judges across the country. She is also a life bencher and the president of the National Association of Women Judges, Nigeria.
While we can confidently say that Nigeria has come a long way in terms of women achieving leadership positions in the legal profession, there is still much work to be done. The journey towards achieving true parity and inclusivity remains ongoing. Inclusivity is the campaign theme of the 2024 International Women's Day celebration tagged Inspire Inclusion, which is also part of the Naujin vision for women in law. There are still many challenges inhibiting women from reaching the zenith of their careers. Some of these challenges include domestic impediments, difficulty in maintaining a work-life balance, lack of support in the home, working conditions that are not favorable to women, such as frequent postings of women with young families, gender bias, the belief that certain positions are more suited to the male gender, lack of mentorship programs, to mention a few. Women have been exceptionally blessed by God with innate skills and ability to multitask, which can enhance and support nation building. It is therefore imperative to recognize the invaluable need for the participation of women in policy making and to strive to ensure their inclusivity in the promotion of policies that are gender sensitive and which provide greater access to justice. There is no gainsaying the fact that women have so far also contributed in shaping the legal landscape globally.
Justice Kekere Ekun will assume leadership of the Supreme Court at a time the President has approved a pay rise for judicial office holders. We have that and some other top legal stories in the news.
We begin with the reports that President Bola Tinubu has signed the Judicial Office Holders' Salaries and Allowance Bill into law. In June, the National Assembly approved the bill which grants a 300% salary increase for judicial officers at the federal and state levels. The special advisor to the president on Senate matters, Senator Bashir Lado, said the move underscores the president's absolute prioritization of the welfare of Nigerian workers above all else, just like he did when he recently put on hold an ongoing Federal Executive Council meeting to assent to the new national minimum wage bill of 70,000 naira. Following the passage of the bill, the Chief Justice of Nigeria will reportedly get an annual salary of 64 million naira. The President of the Court of Appeal will be entitled to 62.4 million naira, while justices of the Supreme Court will earn the sum of 61.4 million naira each. The Attorney General of the Federation and Minister of Justice, Senior Advocate of Nigeria, Lateef Fagbemi, says by this historical assent, the yearning of judicial officers across the country for better conditions of service has been met. At the Court of Appeal in Abuja, Justice Inyang Eko of the Federal High Court, Abuja, has set aside the orders barring 3 chieftains of the People's Democratic Party (PDP) from further attending any meeting of the party's National Executive Committee or participating in deliberations or proceedings of the meetings in any manner. The PDP chieftains are the party's former national chairman, Uche Secondos, sacked Rivers Governor Celestine Omeha, and a former deputy speaker of the House of Representatives, Austin Okpara. In 3 separate judgments on Friday, a 3-member panel of the Court of Appeal unanimously upheld the appeals filed by Secondos, Omeha, and Okpara for being meritorious. The appellate court held that the issue of whether members of a party should attend the party's meetings or participate in any of its activities are issues to be determined by the political party. It held that the Federal High Court ought not to have entertained the cases because it lacked the jurisdiction to hear and determine the suits dealing with issues within the realm of the internal affairs of the political party. At the High Court of the Federal Capital Territory, Justice Silvanus Orji has extended the order restricting participants in the End Bad Governance protest against the federal government to the Moshood Abiola National Stadium in Abuja. Justice Orji extended the order following an application to that effect argued by Senior Advocate of Nigeria, Ugu James Onoja, on behalf of the Minister of the Federal Capital Territory. At the proceedings, all the defendants were absent in court and were not represented by any legal practitioner, but the FCT minister, through his lawyer, drew the attention of the judge to a statement issued by one Damilare Adenola, who threatened that the nationwide protests may be extended beyond the initial 10 days. The counsel argued that since they were not in court and no one knows their next plan of action, it would be in order to extend the order to ensure that the peace of the FCT is not unjustly disrupted. In a brief ruling, the judge granted the request and affirmed that the order of July 31, 2024 remains valid and in force. The judge subsequently fixed August 22, 2024 for hearing of the motion on notice. In Lagos, the Federal High Court has ordered the interim forfeiture of a cash sum of $2.045 million linked to the former governor of the Central Bank of Nigeria, Mr. Godwin Emefiele. Justice Akintayo Aluko also ordered the interim forfeiture of 7 landed properties linked to the suspended CBN governor. The lands are situated in Ikoyi and Lekki areas of Lagos, as well as Agbo in Delta State. Justice Aluko also ordered the interim forfeiture of 2 share certificates of Queensdorf Global Fund Limited Trust. In urging the courts to forfeit their assets, EFCC counsel, Senior Advocate of Nigeria, Rotimi Oyedepo, said the money and other items sought to be forfeited are reasonably suspected to be proceeds of unlawful activities. The court has ordered the EFCC to make a publication of the order so that anyone with interest in the money can come forward to lay claims to it. And we round off with the report that an appeal court in the United States has rejected Nigeria's sovereign immunity defense to the enforcement of a $70 million investment arbitration award won by a Chinese firm, Zhongzheng Fucheng Industrial Investments Company Limited. The majority ruling, in a verdict delivered on August 9th, affirmed the judgment of the U.S. District Court for the District of Columbia that held that the arbitration award is enforceable. Nigeria is alleged to have violated both fundamental and commercial rights of the Chinese firm. A French court had earlier authorized the seizure of the 3 presidential jets due to the ongoing dispute between Zhongzheng and the Ogun State government. However, the presidency said it is aware of the development, accusing Zhongzheng of attempting to take over offshore assets of the country through subterfuge.
And this is where we adjourn proceedings for today. Do remember to check out the Channels TV website for a replay of this episode of the program, as well as past episodes. Please also send in any feedback via our social media handles. I'm Shola Shoyele. Thank you for watching, and see you next week.